Mr. David Davis.
Thank you, Madam Deputy Speaker. On the 20th of January last year, I opened a backbench debate on the use of lawfare and slaps by those seeking to suppress public debate, bully people into submission and conceal vital information that is in the public interest. Free speech matters. That's a truism of our age. But why does it matter? There are many reasons, but an important one is that free speech helps keep our society clean, free of corruption, of criminality, and the abuse of power. Now, typically, such corruption is curbed when whistleblowers expose it, when journalists in a free press report it, and when politicians or judicial authorities act on it. So overmighty men and organisations who have acquired their power and money through corrupt means hate free speech and use their wealth to suppress it. To do that, they use slaps, strategic litigation against public participation. Slaps are a suite of litigious techniques used by corrupt plutocrats designed to intimidate, suppress and destroy those same whistleblowers, journalists and politicians who are trying to expose malpractice. They're designed to do this even when the plutocrat has no substantive case at all. They're designed to grind down decent, honest, public-spirited people and ruin them. Earlier this week in the House of Lords, the government introduced the first legislative changes to designed to tackle this issue of lawfare, this issue of slaps. In the intervening period, the problem has been exemplified by the actions of the businessman Mohammed Mersi. Now, I've already named this gentleman several times in this House in connection with our former colleague Charlotte Leslie, who had to face 2.5 years of fighting Mersi's spurious legal claims against her. That court case was concluded in Charlotte Leslie's favour a few weeks ago. The judge found that Mersi's case failed on the facts. But importantly, he also added that several aspects of Mersi's conduct gave real cause for concern about the intent behind his legal case. Mersi delayed the start of defamation proceedings, took an exorbitant approach to litigation, and pursued an unnecessarily complex case. He also pursued a data protection claim and defamation claim in succession rather than properly in one action, thereby spinning out the case and maximising the stress and cost on Charlotte Leslie. This was clearly an attempt to bully, intimidate and financially ruin Miss Leslie in order to suppress the truth. They are the classic characteristics of a slap case, designed to destroy free speech, not to deliver justice. The judge also noted that Mersi offered to drop his claim against Charlotte Leslie if he got his way and was given the green light to launch a rival group to Miss Leslie's Conservative Middle East Council, a clear attempt to blackmail the Conservative Party via a sort of judicial hostage-taking. These are all standard slap tactics. And this is unsurprising, given that Mr. Mersi was represented by Carter Ruck, the go-to law firm for every bad actor seeking to undermine and misuse British justice. But Carter Ruck is not the only law firm willing to aid legal intimidation by dishonest and dishonourable means, if they pay the right price. These include CMS, Mishcon Rea, Skadden, Taylor Wessing, Shillings, and Harbottle and Lewis. Now, Charlotte Leslie isn't alone in facing lawfare at the hands of Mr. Mersi. He's also suing BBC Panorama and has threatened The Guardian, Chatham House and Private Eye. He's also used legal threats to bully King's College London into withdrawing a report on tax avoidance, tax evasion, economic crime, and the way this has impacted our public space and politics. The report was written in 2021 by the Right Honourable Member for Barking, who is a visiting professor at King's College and a long-standing campaigner against international corruption. The report was published in May 2022, but due to Mersi's threats, it was removed a few weeks later. This report was in the public interest. highly relevant to our debates on the role and influence of Russian oligarchs and on the economic crime bill. But access to it by the public, and indeed by members, was prevented. So why did Mercy do this? Because he did not like what was being written about him. Because our laws allow those with deep pockets to bully people, suppress negative commentary in the media, and stop us holding their actions to public account. Because he's rich enough to do it. But what was it that Mr. Mercy wanted to conceal with his slaps? Well, in a word, the truth. A long history of involvement in corruption, in bribery, and in buying access to politicians. And Mercy is a wealthy businessman who made large sums of money in Russia, Uzbekistan, Kazakhstan, and Nepal, all countries where corruption is rife. In 2005, Mercy made $4 million arranging the acquisition of a Russian telecoms company on behalf of a company he knew was secretly owned by a powerful Putin ally, the then Russian telecoms minister Leonid Rayman. He made another $1.5 million buying and selling on a Russian telecoms venture Comet that was backed by a Russian general. In the UK, Mercy used his fortune to gain access to powerful people. He coined the term access capitalism, describing his own attempts to gain access to the royal household and government ministers with payments to Prince Charles's charities and the Conservative Party. He and his partner gave £750,000 to the Conservative Party, and he makes no bones about what he thought he was buying. When the Pandora Papers were leaked in 2021, they exposed some of the most egregious instances of corruption, economic crime, and money laundering. And Mercy was in the thick of it. Following the leak, a joint investigation by the BBC and The Guardian revealed that he profited from a corrupt deal involving the Swedish energy company Telia and a high-profile kleptocrat in Uzbekistan. Now, most of their investigation relied on court documents and a settlement reached between Telia, the company Telia, and the US Department of Justice following a 4-year investigation into Telia's activities. A leaked internal company report described the activities of a consultant called Mr. XY, who it transpires is Mohammed Mercy. It said some of the payments to Mercy, and I quote, may have been utilised to improperly acquire regulatory benefits and or secure the go-ahead of the transaction. Improperly acquire regulatory benefits. The report recommended a Telia sacking. And it's not surprising, given that Telia's former chief compliance officer said he had been, and I quote, involved in one of the biggest corruption scandals we have seen in Sweden, close quote. Mercy helped facilitate a 220 million purchase of shares from a shell company owned by the daughter of the Uzbek president at the time. This share purchase was, in fact, a concealed bribe. That was the clear view of the US Department of Justice. Mr. Mercy himself pocketed a $500,000 success fee following the deal. He claims he was employed by Telia at a rate of $10 million a year for his advanced skills and aptitude for negotiating. But despite these apparent skills, he claims not to have realised a financial arrangement he helped design facilitated a multi-million-dollar bribe. Now, either he knew it was a bribe, or he was extremely naive and therefore grossly overpaid. I know my view, but I'll leave the public to decide theirs. This is precisely why the Right Honourable Member for Barking wrote about Mr. Mercy in her report last year. This story had already been reported in The Guardian and the BBC. This is the first paragraph he wanted removed from the Right Honourable Lady's paper, and I quote exactly. The figures behind the Pandora leak are mind-boggling, and the documents contain many scandalous stories which really confirm how utterly unlawful the abuse of offshore has become. The papers bring to light how Conservative Party donor Mohammed Mercy allegedly used BVI-based companies to profit from apparently corrupt deals between a Swedish telecoms giant and a key power broker in the kleptocratic regime in Uzbekistan. They reveal the offshore structures deployed by Putin's inner circle of oligarchs and allies to buy million-dollar properties along the Monaco seafront. They demonstrate that money flows into onshore tax havens, such as US states like South Dakota, where there's around $360 billion hidden in secret trusts, including money that could have been derived from corrupt regimes or criminal activities, end of quote. And this is the second paragraph he wanted removed. Comments from Mohammed Amersi, a Kenyan-born telecoms millionaire, who, as previously discussed, was named in the Pandora Papers, seems to confirm that political donations can have a sinister purpose, after he described his frustrations at what he called access capitalism. Amersi previously admitted to buying access to Prince Charles, and he's also donated $750,000 to the Conservative Party since 2017. He claims to have paid $250,000 to become a member of the party's advisory board, which has regular meetings with Boris Johnson and leading cabinet members, and claims he was promised the chairmanship of a new body, the Conservative Friends of Middle East and North Africa, a promise that has yet to materialise. The role would have given him significant power and influence, as he would have acted as a link between governments in the region and British ministers. Amersi is now mired in an international corruption scandal. End of quote. The Right Honourable Member for Barking's report, entitled Losing Our Moral Compass, was about illicit finance and its corrosive impact. It summarised and analysed the features of many corruption cases in the public domain. It was a well-researched and argued paper designed to inform public debate, written to show how dirty money threatens the integrity of our economy and our political institutions. Ironically, what followed illustrates how right she was. Within days of the report being published, King's College and the Right Honourable Member for Barking received legal threats. Through his lawyers at Carter-Ruck, Amersi branded the report highly defamatory. He demanded an apology and that passages referred to him be either changed or entirely removed. Amersi bullied King's College into removing the paper. As notional defenders of academic freedom, they should have stood up to him, but they capitulated in the face of his threats. And his threat effectively silenced the Right Honourable Member for Barking and suppressed her vital work, exposing economic crime and dirty money. We know that Amersi is no stranger to using his financial might to get what he wants. He's previously paid to meet senior members of the royal family. But organisations like the Conservative Party and Buckingham Palace take serious reputational risks in associating with people like Amersi. Amersi's attempts to remove important information from public view are a textbook example of strategic litigation against public participation. They're clearly an exercise in lawfare. So here we have an individual with deep pockets who can use British lawyers and courts to suppress the publication of information which is clearly in the public interest. This is done in the knowledge that lengthy legal battles will likely bankrupt politicians, journalists, academic institutions, whistleblowers and others who are brave enough to tell the truth about public corruption. Amersi, like many oligarchs with huge wealth of doubtful origin, is in the business of silencing people. His actions are an example of how the rich and powerful can silence anyone who criticises them. The kleptocrats, oligarchs and bad actors do not care if that means stifling free speech, academic freedom and public debate. And now they're even prepared to try to silence elected members of Parliament and to block the publication of information that's plainly in the public interest. We find ourselves in a dangerous situation where the abuse of the legal system is now damaging the very core of our democracy. The cases faced by the Right Honourable Member for Barking and by Charlotte Leslie serve as a glaring example of this. It's to the disadvantage of the whole country when public interest investigation by Tom Burgess, HarperCollins, Catherine Belton, Elliot Higgins, Open Democracy, Oliver Buller and the Bureau of Investigative Journalism are shut down. Fortunately, the government responded very quickly to our debates on this issue last January of last. It almost immediately held a major consultation, which resulted in proposals for reform. And on Tuesday of this week, it introduced the first anti-SLAPP measures and economic crime bill, currently making its way through Parliament. The measures will empower the courts to strike out SLAPPs before trial. They'll also prevent courts from ordering defendants to pay claimants' costs in relation to a SLAPP claim, unless misconduct by the defendants justifies it. Once a claim is deemed to be a SLAPP, the burden will be on the claimant to prove that their claim is more likely than not to succeed. If not, the claim can be struck out. This is a welcome reversal of the burden of proof. Taken together, these measures are a great win for those looking to shine the spotlight on economic crime and speak truth to power. But we must go further, Madam Deputy Speaker. As things stand, the measures only apply to economic crimes. Approximately 70% of the crimes listed in April 2022 Foreign Policy Centre report were connected to financial crime and corruption. But slaps have also been used to silence reporting on human rights abuses, on labour practices, on regulatory non-compliance, and an array of other abuses that don't relate to economic crime. To be truly effective, we must broaden anti-slap provisions so they apply to all defamation lawsuits. Because ultimately, we want to ensure that people like Wagner's chief, Yevgeny Prigozhin, who's been in the news this week, people like him are not able to silence and intimidate journalists, as he did to a Bellingcat reporter earlier this year. So I welcome the commitment by Lord Bellamy on Tuesday. The government will complete the jigsaw as soon as suitable legislative vehicle appears. And this issue will not end with reforms to defamation law. Data protection law and subject access requests are becoming yet another weapon for bullying people into silence. And we also need proper regulation of private investigators, who in many instances have enabled slaps through intrusive and often illegal surveillance or hacking. Justice Nicklin, in the Charlotte Leslie case, said the tactic Mercy's lawyers used against Charlotte Leslie, bringing separate claims in succession, can be a hallmark of abusive conduct. I think he was being delicate in referring to slaps. We could improve the government's proposals by allowing the courts to make the law firms and solicitors involved in slaps cases pay the costs to the public purse, taking the fight directly to those who enable slap suits. The London lawyers I listed earlier, Carter Ruck and the rest, have designed a litany of tactics not to promote justice, but to suppress truth, not to protect reputations, but to silence legitimate criticism, not to ensure accountability, but to cover up corruption. That behaviour should not go unpunished. They should be made to meet the costs of wasting the court's time. Our legal system is a source of pride. Britain is home to some of the fairest and best courts in the world. We cannot allow individuals with deep pockets and questionable motives to exploit our justice system and destroy our reputation as a trusted jurisdiction. Expanding anti-slap measures will put an end to this perversion of our legal system, which seeks to intimidate, threaten and suppress British journalists, academics, civil society and sitting members of Parliament. We made good progress, but if we fail to understand the magnitude of this issue and fully address this problem, then, as the Right Honourable Member for Barking rightly stated in their report, we are truly at risk of losing our moral compass.
Minister, Mr. Mike Freer.
Thank you, Madam Deputy Speaker. And first of all, may I thank my right honourable friend, the member for Halton, Price and Howden, for securing this important debate this evening. And it gives me the opportunity to restate the government's commitment to freedom of speech and the protection of journalists. First, let me emphasise that investigative journalism is a central plank and of central importance to a functioning democracy. The UK launched a national action plan in 2021 to ensure that we continue to foster an environment in which journalists feel safe from physical harm and intimidation, and where those who threaten them are properly held to account. Our aim is to ensure that journalists operating in the UK are as safe as possible, reducing the number of attacks on and threats issued to journalists and ensuring those that are responsible are brought to justice. Now, Madam Deputy Speaker, the UK may not face the same challenges as other states, but it is clear that journalists operating here still face threats to their personal safety, largely through online abuse. However, as we rely on journalists to hold powerful actors to account for our collective good, lawfare that targets our public watchdogs through aggressive, intimidatory tactics must be stamped out. Madam Speaker, Russia's invasion of Ukraine brought home the urgency of government action on strategic lawsuits against public participation, known as SLAPs, as my honourable friend has laid out very clearly. An increasingly common lawfare tactic, with reports that hostile states could finance litigation in the UK to obstruct worthwhile investigations into corruption and other wrongdoings, have become more prevalent, again, as my honourable friend has laid out many times. We know that the government's decisive action on sanctions has already urged firms to review their Russian client list, mitigating threats to national security. Insurers are increasingly cautious in granting professional indemnity insurance, reflecting greater scrutiny of Russian-linked litigation. And as this House will recall, the government published a call for evidence on SLAPs in 2022. And I wish to thank the 120 respondents to this call for evidence who submitted evidence of the highest quality. Through that invaluable evidence and a series of stakeholder engagement roundtables, we heard the shocking impact these cases can have on the well-being and livelihood of investigative journalists who report under immense financial and psychological pressure. So that we as a collective are well informed that they must be protected. That roundtable ensured that we were well informed that they must be protected so that they are able to continue their valuable work. SLAPs present a novel challenge to free speech, and we are immensely grateful to the call for evidence respondents for helping to ensure that we get this right and deliver the outcome we want to see. Free speech is a fundamental cornerstone of our democracy, and so I am pleased to confirm that the government has acted decisively to legislate, tabling amendments to the Economic Crime and Corporate Transparency ECCT bill, which introduced measures to tackle SLAPs related to economic crime. The government still intends to introduce comprehensive anti-SLAPs legislation when parliamentary time allows. And if I may, Madam Deputy Speaker, I might gently suggest that my right honourable friend applies for PMB, because if a government legislative vehicle may take some time to appear, a PMB in the next session might be a suitable codicil to this particular piece of legislation. And we do intend to go further, but we believe that the measures that we have introduced will catch the majority of SLAPs. At least 70% of the cases referenced in a 2022 report about SLAPs by the Foreign Policy Centre and Article 19 were connected to financial crime and corruption. These provisions should therefore target a significant proportion of these cases. And recent court cases have shown that SLAPs are difficult to identify, and there is notable difference in legal and judicial opinion on what constitutes a SLAP, both domestically and overseas. And to rectify this, we have introduced a statutory definition to enable clearer identification of SLAPs related to economic crime, according to common characteristics. These characteristics may include aggressive pre-action communications and targeting of individuals, where their publishers would be more appropriate. Today, we know that defendants are intimidated by the prospect of years of litigation that require expensive legal defence, and we have therefore introduced an early dismissal process which will effectively stop claimants from financially and psychologically exhausting their opponents via abusive means, cutting short cases which have no merit. And with respect to economic crime, no longer will claimants be able to suppress legitimate investigation into and reporting on matters of public interest by bringing baseless claims. The crippling costs currently borne by SLAPs defendants will be addressed through a new cost protection regime which will ensure that journalists and free speech advocates are able to litigate without fear of bankruptcy. This regime will be introduced in secondary legislation once the principles set out in statute. This regime will frustrate a central plank of SLAPs claims, the weaponisation of costs. In addition to stakeholder engagement, that continues, and it will be a vital part of our monitoring effort to ensure that the government's response to the issue of SLAPs is appropriate and effective. We're working closely with the Solicitors Regulation Authority, who should be applauded for action on SLAPs. In February, they published a thematic review of the behaviour in disputes of 25 law firms suspected of SLAP activity, a deep dive into the conduct that may breach ethical or regulatory duties. They also issued additional guidance on conduct in disputes in March. This shows that our system of regulation is adapting at pace to novel challenges. But I must undermine, Madam Deputy Speaker, that the vast majority of legal professionals operating in this jurisdiction do so with the utmost integrity and regard for the rule of law. Therefore, it is vital to protect the integrity of our legal system and our judiciary from reputational risk that slaps pose. Our common law system is world-renowned precisely because of the quality of our practitioners and the procedures that we use, and it must remain that way. Whilst the importance we place on access to justice and an independent judiciary naturally leads to foreign litigants choosing to do business in our courts, we must not and will not allow the process and procedures to be abused. And for most improper purposes, that must be stopped. And that includes, as honourable members and right honourable members have laid out, including attempts to conceal economic crime. Madam Deputy Speaker, if I may end, I would like to thank my right honourable friend for continuing to champion this critical issue and to thank our stakeholders who have tirelessly campaigned against the abuse of the legal system. I would like to end, if I may, by repeating back to my right honourable friend his own words. He said, "Our legal system is a source of pride. Britain is home to some of the fairest and best courts in the world. We cannot allow individuals with deep pockets and questionable motives to exploit our justice system and destroy our reputation as a trusted jurisdiction." The government could not have put it better.